Welcome to another in a series of Glasgow Wants to Know. Tonight we're going to be talking about the fiscal court. The Constitution of Kentucky provides that each county will have a fiscal court consisting of a county judge, 3 justices of the peace, or 3 commissioners. The system that we have in Barren County now consists of the county judge, and the justices of the peace are more commonly known as magistrates. The legislature provides a means of changing the makeup of the court from one to the other by means of the filing of a petition. A petition has been filed in Barren County to change the makeup of the Barren Fiscal Court from the magisterial system as it now exists to a commissioner system. This, as a result of this petition, the citizens of this county this fall at the general election will vote whether to retain the system as it now exists or to change it. Tonight we are going to discuss the proposal, hopefully both pro and con. To do that, I have as my guest County Judge Executive David Dickerson and Bobby Richardson, former Speaker of the Kentucky House and now a practicing lawyer here in Glasgow. I think perhaps we should start tonight by defining what a fiscal court is. What is a fiscal court, Mr. Richardson? Well, what's its function?
The fiscal court's function is to manage the administration of the county, more or less a board of directors, but having certain powers. The county judge, of course, is a member of the fiscal court, and together they administer the county's business and financial affairs, provide the services, do all the things that county government we expect it to do.
In essence, it is the legislative body of the county government.
It's legislative, but a bit more than legislative too, because it does have some administrative functions that we don't normally consider part of a legislature. Matter of fact, the legislative functions of the fiscal court are rather limited by the Constitution, only certain areas, and limited in those areas can a county fiscal court legislate.
It can only legislate on the subjects that are permissible by action of the state legislature.
That's right, and by the Constitution. A few years ago, I suspect it was about 1980, the legislature passed the Home Rule Bill, which was an attempt to transfer more powers back to the fiscal courts so that they could make some decisions that would fit local problems better. And the legislature adopted that, and the then highest court in Kentucky, the Court of Appeals, ruled much of it unconstitutional, therefore putting the fiscal courts back in this limited position, subservient in their role to the state legislature.
Judge Dickerson, perhaps before we get into the question about the change, you would enumerate some of the functions of the court.
Well, generally the court has authority granted to it by statute, as Mr. Richardson said. Those powers are enumerated in what we call, or what I refer to as, the power statutes. I think they were enacted in Chapter 67 of the Kentucky Revised Statutes that give very specific areas where the court has authority to legislate action or to take certain steps. And basically the court is, Bobby and I will disagree on this one a little bit, not a lot, but the court is primarily a legislative body as I interpret it, and has the authority to buy and sell real estate, has the authority to enact county laws basically through ordinances, and does have the authority to pass a county budget, very similar to the authority of the the General Assembly, and likewise the court has the authority to pass a county road and bridge program which would provide for the transportation needs of the community. Administratively, the statutes provide that the county judge executive will administer the ordinances and the actions of the fiscal court and exercise all the executive authority that's not granted specifically to the court as a whole. Since the judge executive is a member of the fiscal court, then his statement about the administrative functions is probably valid, because the judge does have the authority after the court adjourns from its regular meetings to administer those orders that the court passes, because the court's a court of record and speaks through its own orders.
It also sets the tax rates
Yes.
for the county, and actually the school boards also.
Right.
Presently, how is the court constituted? And again, I'm directing it to Judge Dickerson.
At the present time, Barren County Fiscal Court is composed of the county judge executive, the office it's my pleasure to occupy at this time, and 7 justices of the peace, or magistrates as they're commonly known. The statute allows a number of from 3 to 8 magistrates who are to be elected by the members of their respective districts to serve on the court. In Barren County, we have a county judge executive and 7 justices or magistrates.
And they are elected from districts.
Yes, that's correct. The county was reapportioned by the court preceding this one in 1992 to make some changes in the legislative districts or magisterial districts based upon some population shifts in Barren County. It resulted in a change in 2 magisterial districts, but the districts are substantially the same in 1996 as they were in 1983, as a matter of
Now,
fact.
who, under the present system, who determines the districts? Who does actually enacts the apportionment?
The fiscal court has the authority, I think it's in, once again, in Chapter 67, to reapportion the county at any time. The court might address that question. So an action of the court is required to reapportion the county under the justice of the peace or magisterial system of government. So and the court's required to do it under certain constitutional questions, required to do it every 10 years after the decennial census, and that was performed in 1992 as it was before that in 1982. As I said, the districts are substantially the same now as they were in 1982. There was some, I think, a shift in the boundaries between District Number 1 and District Number 3 that resulted in about 800 citizens being moved from one district into the other, I think from 3 into District 1. So the fiscal court initiates any change in the magisterial boundaries that when it decides it wants to, and it's required to do so following the publication of the United States Census. The court then would appoint 3 commissioners based upon nominations by the county judge executive, all of whom have to live in different districts. No 2 can live in the same magisterial district and serve on the reapportionment commission or apportionment commission. I'm not sure exactly how it's delineated, but that's generally the procedure. Then those 3 people, along with the county clerk, make a report and a formal recommendation back to the court within a specific time period. I believe 60 days, but it's 60 to 90-day time period. And then the court may adopt or refuse to adopt the report of that commission.
Mr. Richardson, insofar as you know, has the court here in Barren County ever consisted of commissioners?
No, sir. To my knowledge, we've always had the justice of the peace system. Most people call them magistrates, but by law they are justices of the peace. We haven't always had 7 magistrates either. In about 1960, there was an additional seat added to the fiscal court. There was a lawsuit filed sometime after reapportionment. Lawsuits became popular legislatively, and a suit was filed here in Barren Circuit Court to reapportion the county. That was back before we had the reapportionment statute. And as a settlement of that lawsuit, there was an additional member added to the fiscal court, and that was the Glasgow district. And if my memory is correct, Squire Robert Bishop was the first one to fill that new seat.
Your memory is good. I remember that. I remember the lawsuit and so forth. Insofar as the apportionment is concerned, what is the basis for the creating the district? By that I mean, is it based on population or is it based on area? What is the basis for it?
If my memory is correct, and I believe that it is, it's population. I believe it says as nearly equal as possible is the statutory language. And of course, we haven't always had, as I said just a moment ago, an apportionment statute. I believe 1982 was the first time that we were required by law to reapportion the magisterial districts.
Well, what actually brought on the suit that you're talking about in the 60s was the fact that you, by reason of Glasgow growing with industry and so forth coming in here, you had an increase in the population, and you only had one magistrate representing the city, and it was fast approaching, as it is now. About half of the population resided within the city limits of Glasgow, and they only had one magistrate. And that's what brought on that lawsuit. And
I believe that even that magisterial district included some rural area outside of Glasgow.
It did. It did. Now, Judge Dickerson, what is the proposed change?
The change that was petitioned, or the question that was petitioned to be put on the ballot, would make the following change in county government. In fact, the petition, the question that will appear on the ballot is basically, are you for or against a fiscal court composed of the county judge executive and 3 commissioners? I think that's the question. The change that would result would require new district boundaries to be drawn for the 3 commission districts. There would then be a fiscal court composed of the county judge executive and 3 commissioners who would be elected by the entire voting population of the county. Each member would be required to live in a district and would represent a district, but would gather votes from all the registered legal voters in the county. That's the proposed change.
Where did the proposal originate?
There appears to be a trend that I say a trend when I see 6 or 7 or 8 counties across the state of Kentucky considering the same question. There appears to be a trend in Kentucky to examine the potential to change fiscal courts from justice of the peace form to a commissioner form. I think Barren County is the 6th or 7th county in the state to have this question on the ballot. There have been a number of stories in the Courier-Journal regarding the changes in the eastern part of the state. I think we're the westernmost state to consider the question this fall's election. Frankly, I think there are a number of people, given the present composition of fiscal court, that would like to see a change in Barren County. They think that having a voice on all 4 members of the court, the electorate having a voice, would be a positive step. I think people would like to see members on the court, all of whom have a much broader county-wide perspective, rather than to be more narrowly focused, to have tunnel vision, if you will, for one specific area as opposed to the county as a whole. And that appears to be the general consensus of those people that have spoken to me about the question.
Well, who initiated the petition here in the county?
There was a contact made into my office by a citizen who was desirous of a change in the fiscal court. And I think generally the desire of this person was to see the number of justices reduced from 7 to some number. and the individual had read the articles in the Courier. He said, "What about this commission form?" I said, "I don't know anything about it. We've never had it here." And so he asked if I would be willing to look at the statute to see what steps were necessary. Looked at it, gave him the petition, and it began to circulate. In fact, I signed the petition. I think it's something that the citizens of our community or our county would like to speak on.
We'll get back to that in a moment as to why you think we should do it.
That's fine.
How many, or about how many counties, if you know, Mr. Richardson, that has the commission form?
Well, I'm not sure that I could name them all. I do know that Louisville, Frankfort, or Franklin County, Ashland, if my memory is correct. I don't know where you consider Fayette County or not, since they have urban county government, but they did have it before they had urban county government. Paducah has the commissioner form of government, and Scott County, I believe, adopted it a few years ago, but maybe are in the process or attempting to go back to the old form. Now, there may be another county or two. David may have a list of them there, but it's a very small minority when of the 120.
Go ahead.
I do. There are presently 15 counties across the state that have a commission form of government. Among those, I could list them, but it's not. I will if you want me to.
No, I don't think that's necessary.
There is, however, about a third of the population in the state of Kentucky represented by the commission form of government. So the counties range in size from Bath County of about 10,000 to Jefferson County of 670,000 plus. Scott County, that Mr. Richardson mentioned a minute ago, has voted to go from the commission form back to the magistrate form. So this is a step that's not irreversible. Citizens might see that this form is not one that would be desirable, and it's a question that can be reversed basically by referendum.
When did Georgetown go on the commission?
I don't know when Scott County initiated the commission form of government, but I think they voted to return to the Justice of the Peace form either in 1994 or 1995.
Let's assume that we vote for it here and it passes. When could you have another election to go back to the old system?
1998.
What, for?
2 years following this referendum.
You have a referendum every 2 years.
Well,
I thought the statute said 4.
I'm sorry, it may say 4. I know that you can't change. You can only change one time in an interim between the election of the fiscal court and the next election of fiscal court. There can be one change. Whether that's a 4-year period of time, that's probably accurate. But the election that took place, that's going to take place in 1996, if hypothetically the county does vote in favor of the change to commissioners, then those commissioners would be elected in 1998, would serve from January 1999 to January 2003. If in that interim period between 1998 and 2002 a petition was presented to the county judge executive, are you for or against a fiscal court composed of the county judge executive and from 3 to 8 magistrates, which would be the question to reverse the decision, then that election would have to be held sometime in the time frame of 1998 to 2002. So it would be in that 4-year term, Mr. Barrickman. It might not be specifically 1998. I think the statute requires it being a general election when state or federal offices are chosen.
Yes. In other words, if it should pass this November,
yes,
you would not go on under the commission form until after the terms of the present magistrates have expired.
That's correct. This question, should it pass, has absolutely no effect on any sitting member of fiscal court. The seats, we for all intents and purposes, we will all vacate our seats January the 3rd, 1999. Those of us that are re-elected will be sworn and serve beginning in January 1999. And if this commission form passes, the boundaries are drawn, and 3 commissioners would be elected in November 1998 instead of how many ever magistrates, 7, or justices, 7 as the case is presently.
Do you know, Mr. Richardson, whether Jefferson County has ever had the magisterial form?
I don't believe they have, but I can't say that for sure. Of course, I can't remember back as far as some might, but they've had the commission form of government ever since I can remember. One of the first commissioners that I remember, as a matter of fact, originally was from this area, William Walden, Judge Cass Walden's brother.
I think my memory may be incorrect about this, but I think that there was a petition to change from the commission form to the magisterial form in Jefferson County not too many years ago. And it got on the ballot, but got on incorrectly because the question allowed them to vote yes or no, and not in accordance with the statute. And I think there is a case, I'm pretty sure there was an attempt made, but it failed because of that.
Yeah, the statutory language is very specific. The question is for or against.
And I think it was a Jefferson County case that held that if the question was yes or no on the ballot, that it didn't comply with the statute, and therefore any election was invalid. Void, as a matter of fact, I think is what they held. Void election. You said you signed the petition, Judge. Why do you think that we should make the change?
The signature on the petition indicates that I'd like to see the referendum take place. After studying the question and after talking to some of my peers in counties that have a commission form, the general consensus among judge executives and even among some commissioners is that the system works much better because the members of the court who have responsibility for the county's budget, who have responsibility for county road improvements, who have responsibility for ordinances enacted in the county, who have responsibility for the setting of tax rates, and who basically make the outline for the administration of the county's affairs with regard to finances, transportation, and the like, have a fully countywide perspective, or much broader countywide perspective under the commission form than they do under the Justice of the Peace or magisterial form. The county judge executive from Graves County and the county judge executive from Greenup County are two with whom I spoke, because those two counties both have the commission form of government. Both of them are very similar in population to Barren County, in the mid 30,000 population range. And in fact, I think Judge Carpenter from Greenup County said it's just a fairer way to do things. Everybody looks at broad questions, and even though the commissioners A, B, and C live in a specific district, bounded very similarly to the magisterial districts, those commissioners must look to all the citizens of the county, the legal voting citizens of the county, for support for their reelection. And if an incumbent chooses to run, then he must do those things to gain the nomination in his district. But he must seek election in the November general election from all the voters in the county. Well, in fact, in Barren County, our situation would be that the nominations would take place by vote of the entire county, as well as the general election, should we have primaries in either one of the parties. So the comment from Judge Carpenter in Greenup County was, it's just a fairer way to do things, and that's a quote from him. It just seemed to lend itself toward more fairness. Judge Smith in Graves County was occupied in a meeting today. I didn't get to speak to him, but I spoke to his 911 coordinator, a gentleman named Ronnie Lawson, who had lived in the county under the magistrate form of government when they had it in Graves County, and they probably had the commission form in Graves County for 30 plus years. But he lived there under the magistrate form of government, and he presently lives there and serves as 911 coordinator under commission form of government. And he said that it just appeared in the commission form of government that everybody pulled together, that everybody's interests were for the county as a whole, and even though there was a desire on the part of commissioners to do things in their specific districts, that the commissioners recognized the importance of an entire fiscal court pulling together to do those things for the county that were beneficial to all the citizens of the county, because that's what fiscal courts are about. Our primary focus should be an objective look at how we can improve the lives of the citizens of our communities. And according to Mr. Lawson, the commissioners were much better able to do that because of the county-wide perspective that each one of them had than were the magistrates, whose focus with regard to the nominations process and to the general election process was strictly on a narrow, much smaller district wherein they could participate, I guess, if you will, in the old type power politics that if I please this fellow and his family and this fellow and his family, then they influence and control enough votes to make sure that I get my party's nomination. And in a number of cases, that's tantamount to election in counties in Kentucky. Sometimes we have contested general elections for justice of the peace, and sometimes we don't. But specifically in Barren County, the victory in a primary, in most cases, has been tantamount to election in November.
Mr. Richardson, do you agree or disagree? And if you disagree, why?
Well, of course, I didn't come here tonight to really debate this to debate this issue, but I can't say that I believe that everything that Judge Dickerson says is valid. First of all, I don't believe that the people of this county are that narrow-minded, as he seems to indicate. Secondly, if what he says is valid, then we ought to elect the state legislature statewide. Same theory would apply. I think that what the commission form of government does is concentrates power in the hands of fewer officials. Now, I'm a Jeffersonian Democrat. I'm a conservative. And I believe that power ought to be dispersed. And I don't particularly believe in the liberal view that fewer people can do a better job. It seems to me that 2 people under the commission form of government can more or less run county government, period. I believe that the statutes provide that in the case where there's a tie, there'd be 4 fiscal court members, that 2 of them voted one way and 2 another way, that the county judge executive would then cast the deciding vote, would get 2 votes, in other words, on appointments and that sort of thing. I also believe that you will make the identity of communities in Barren County less apparent. Of course, I was born and raised in a community called 88, which I'm proud of it. I'm proud of that heritage. I went to high school at Temple Hill, and I'm proud of that heritage and proud of those places, and those areas can identify with their own members of fiscal court. I don't believe that in this county that we've had any difficulty in people not having a broad view. I would submit to you and to Judge Dickerson that Barren County has been, and I think continues to be, one of the most forward-looking, prosperous counties in the Commonwealth. And we've not had, as I see it, any detriment by the present system. I want to develop my idea a bit that we would lose some identity of community here. as I see it, it's distinctly possible that the city of Glasgow would provide the vote to elect all of the. If there's a city-county division, no doubt the city of Glasgow would be able to decide who these people would be. Now, who knows? Maybe Judge Dickerson knows, if he is county judge, what the district boundaries would be. But we won't know that, definitely, until such time as it passes and there's an order placed on the book, because the county judge does apportion. And all the districts could come into Glasgow, for instance. That's possible. And have 3 people from just inside Glasgow. Now, I would hope that if it passes and Judge Dickerson is continues to be the county judge, doesn't resign or die or something of that sort, that he wouldn't district it that way, but it's certainly possible. Of course, some might say that it's more efficient. Well, just one's the most efficient. The most efficient is just to have one person do it and not have anybody to question it. But yet, government is not. It's to reflect views, and it's to reflect backgrounds. It's to reflect cultures, and I think that our present system does that very well. And how Barren County could have been done any better in the last 100 years than it has, be hard for me to fathom. So I think that if it's put forth as a panacea, it's wrong. Now, I know Judge Dickerson and the magistrates have had their disputes, but I would hope that none of us would either vote to change our county government on that basis. I don't think that'd be a very wise principle on which to base it. On the other hand, commission form of government might have some things to recommend it. It might be more efficient, but I don't buy the argument that it gives a different perspective at all. And I think it's more important that we preserve community identities.
If I understand what you said, among other things, if the change is voted in, then the determination of the districts will be made by the county judge executive and not by the commissioners as a whole.
That's the way I understand the statutes.
That's correct. And if I might comment on one other, I, like Mr. Richardson, I think we agree that we're both here for information purposes, and we can debate. He's much more skillful debater than I, due to his years' experience in the General Assembly, to which he referred a moment ago. We don't elect members to the General Assembly statewide because the Constitution doesn't allow it. I don't believe. I think the Constitution is very specific in how members to the General Assembly are elected. And you referred to the Constitution earlier, and it is likewise very specific in how counties might choose their form of government. We're a constitutional republic. We elect representatives, whether they be commissioners elected countywide, magistrates elected by district, representatives elected by district, or senators elected by district. We're bound by the Constitution. It doesn't permit statewide election for representatives or senators, so that's not a valid point. It does permit, however, countywide elections for commissioners, or it allows counties to have their legislative body chosen by district, that those members, the boundaries of which those members draw. Mr. Richardson did a credible job of defending the status quo in Barren County. We have made tremendous progress over the last 100 years, and for the last 2.5 of those, since I've been at the head of this county government, I thank you for the compliment. I appreciate having taken part in that, and we have made huge strides here. We can make bigger strides here. We have the potential to do that, and I think we're headed in that direction. Once the citizens of this community choose the form of government that they want, whether we continue the way we are now, maintain the status quo and don't consider any other change, or whether we look toward what might be a little bit better, it comes to mind. We really won't know until the citizens speak. I think that's the primary focus of what we're here for, is to give as much information to the public as we can so that everyone might make an informed decision based upon what each individual voter believes to be in his or her best interest. That's what representative democracy is all about, and we refer to ourselves on a number of occasions as a democracy in this country and in this state. This is purely a democratic function, small d, but it's purely a democratic function. That means that every voter has the same equal voice on this question. It's the purest way for the citizens to say, this is the way we want to proceed, this is the way we'd like to be governed, or we want things to stay just like they are. And I think the more information we can give to the public, the more opportunity they have to hear comments like they're hearing tonight, I think serves them and the government well, because we will hear them speak.
Does the commission form of government give the county judge executive more power than the magisterial form?
No, the judge executive has the same authority under both systems. The commissioner's function is identical to the function of the justice of the peace or magistrates. The only big difference in the two forms of government is the way they're elected. That's it, pure and simple. The commissioners number 3. The magistrates, as I stated earlier, number anywhere from 3 to 8. We happen to have 7 here. At one time in the past, as you all pointed out, we had 6. We may have had less at some time, but I can't speak to that. I know at one time we did have 6, now we have 7. We could number 3. We could have as many as 8. I know our sister county to the west, Warren, has 85,000 population. They're represented by 6 magistrates, about 1 representative for every 14,000 population. Barren County has 35,000 citizens. We're represented by 7 justices, 1 for every 5,000 population. So, our citizens need to consider all these factors before they make their decision, but the authority of the judge executive is the same, whether there's a commission form of government or a magisterial form of government.
I thought Mr. Richardson alluded a moment ago to a situation where if you had a tie among the 4,
okay,
that the judge would have the county judge executive, and I believe the statute requires a delay of so many days, but that the county judge executive would then have the power to act on his own and make the appointments.
That's correct, only with regard to personnel and appointments to boards and commissions, not legislative questions. That specific question arose in some of the deliberations of Barren Fiscal Court, and I can't tell you the Latin, you fellows might know, but basically if the statute doesn't say that you have the authority to do this, and it specifies that you do have the authority in one area but the other area is left gray, that because it specifically says that the judge executive breaks ties on personnel or appointments to boards and commissions, it precludes him breaking a tie or her breaking a tie on any other question. We had that question arise at one term of the fiscal court within the past year, and the county attorney advised us that in the case of a tie, the judge executive does not have that vote. And since the functions legislatively are identical for the commission and the magistrate form of government, then I must assume that likewise in the case of a 2-2 vote on a commission question that did not relate to personnel or an appointment to a board or commission, that the judge executive would not have the authority to break the tie and the question would die. I can't remember the specific incident where that occurred, but if you fellas find something differently, and we have a tie, a 4-4 tie in Barren Fiscal Court, as we have had in the past, within the past year, then certainly I'd like to know whether or not the judge has the authority to break that tie on questions other than personnel or appointments to boards.
What about on the question of the budget?
No, sir. I do not believe that the judge executive receives any additional vote on any question except personnel or appointments to boards or commissions, because that's specific in the statutes.
I haven't read the statute, but it seemed to me like that up in Floyd County or somewhere they got into that discussion not long ago, Floyd or Johnson County. But the fact is, Judge, that now if there were a dispute, it would take, you would have to convince, for instance, 3 people to agree with you in order to get a tie. Whereas on the commission form, you'd have to convince 1.
That's true.
Which makes a big difference, I think.
Well, we've had questions where, as you put it, I've had to convince 3, and I remember the specific incident now regarding juvenile detention facility in Barren County. We had 3 magistrates and the county judge executive vote in favor of proceeding on the construction of a juvenile detention center, and I don't remember the specific question, but it related to juvenile detention. And we had 4 magistrates vote against it. So there are, even in our fiscal court that's 7 Democratic justices and 1 Republican county judge executive, we have had 4-4 ties. And whether or not their consideration of an issue, or whether or not it was, as you imply, my persuasive power that made them vote with me, I can't say, but we have had ties. And I can't say that it's easier to convince 1 on questions than it is to convince 3. You have fewer to talk to with 1, but generally we have our debates in the open, and the only thing that should persuade is not anything that happens pre-meeting, but those things that happen in the open. You know, we're specifically forbidden from conducting meetings behind closed doors.
Well, Judge, I didn't mean that you were up there trying to convince them to vote one way or the other. I was just using that as an illustration, right, that your position has to be such to have the logical weight behind it that it would convince 3 of them rather than 1. It would have to be more compelling.
Yeah. But a logical, compelling argument is going to sway any open mind, whether they're 3 or 5 or 1, or in the case of the General Assembly, as you well know, 50 in the House or 19 in the Senate.
Don't want to take this away from you, Mr. Barrickman.
Go right ahead.
But of course, the idea is that the more people that you've got discussing things, just so happens that Mr. Barrickman and I practice law together now.
Yeah, that concerned me a little about coming here. I don't know whether I was stepping into the spider's lair or not.
But I think one of the things that we've found over the years is that when 4 of us get together to discuss matters, we all end up coming up with some different and better ideas when we brainstorm around that table, rather than one fella trying to go on his own. And I'm not trying to allude you're trying to go on your own. I was talking about me in the practice law trying to come up with all the ideas and the strategies on my own. So I don't think that it's bad to have several people working on a problem.
And from that perspective, no single individual's ideas are always going to be right. In our society and in Barren Fiscal Court, as we have always encouraged members of the public to attend, we find that a number of the best ideas come from those people that we seek to represent. I remember one forum that I was able to attend with Mr. Richardson, where he talked about the General Assembly and how bills became law, and he referred to his family store at 88, and I've spent many hours in there and had more than my share of bologna sandwiches with his dad. But Bobby talked about the way most laws became laws, and he said generally there'll be a bunch of people sitting around a store having lunch, and somebody will say that ought to be a law. and then somebody will take it to their elected representative, and it'll be fully and freely and openly discussed in either the General Assembly or, in reference to tonight's discussion, the Barren County Fiscal Court. And then when we open that discussion up, when we allow the public full and free access, when we each make the most logical, compelling argument that we can, then we vote our conscience based upon the information that we've gathered, then the people are well served. The government's only as good as the people that it represents. And the thing that we want to encourage everyone to do, all of us here tonight, is to make sure that we all go to the polls and vote on November the 5th, and whether you like the system the way it is, whether you want to preserve the status quo, or whether you want to look at something that may be an improvement, that may be more efficient, that may save your tax money, that may allow a court to look in every question at the full implications for the entire county, is something that each one of you have to decide based upon information that we try to bring you. We're not going to get into a debate here about the merits of each other or the different positions that we take. We want you to be informed. We want you to know that we're focusing solely on bringing to you information on a question that's extremely important to the citizens of this community.
Let's talk about the finances under the two systems. If you go to the commissioner system, how does it affect the financial situation in the county? And I know, and you can say all you want to, that it's not going to affect it one way or another. I know whenever you make a change in government, you affect the finances. The amount of money spent and the amount of money required never stays the same.
Okay. Is that one for me?
That's for you.
Okay. Initially, well, there's one thing we need to clarify. There's been a good deal of incorrect information about commissioners versus magistrates or justices of the peace. Commissioners are no more full-time positions than are magistrates. They are legislative positions. The citizens who would serve as commissioners, should this question be approved by the voters, would have authority only when fiscal court was meeting. So it's a part-time job, very similarly, almost identical to the fact that magistrates is basically a part-time job. They have authority and exercise authority when the fiscal court is in session. Commissioners would be the same. On the surface, one can assume that to pay 3 people would be less expensive to the county than to pay 7 people. And another bit of incorrect information is that we're going to have to pay commissioners more than we have to pay magistrates, is just that. It's incorrect. The fiscal court, the members of the fiscal court, excepting the county judge executive, have the full statutory authority to set their own pay. Our fiscal court set their own pay this year. The county budget that we talked about a few minutes ago had a line item in there for the salaries for the magistrates. It was set at somewhere total about $57,000. The magistrates then chose to raise their pay 2.8 or 3% above that figure that I placed in the budget that I presented to them. So for anyone to tell you as a voter that the commissioners are going to be paid more salary, they're just telling you something that's not correct, because the magistrates have the full authority to pay themselves whatever they choose up to the statutory maximum. There's already been a lawsuit in Kentucky in the past 2 years, I think it was in Clinton County, wherein the Clinton County Judge Executive filed a lawsuit against the Clinton Fiscal Court for raising its pay some 300%. That's a magistrate form of government. So the cost to counties is dependent solely upon the type people that are elected. The commissioners doesn't necessarily mean that you're going to have less salary paid to each one. Doesn't mean you're going to have more salary paid to each one. That's a question that the voters of the county need to ask those candidates, whether they be candidates for magistrate, whether they be candidates for commissioner. They need to be asked for their position. The position needs to be remembered, and then if they don't act exactly as they said they would, then the voters need to be informed of that at the next subsequent election. But the functions of the two bodies of the fiscal court, whether it be composed of commissioners or magistrates, are identical. The only difference is the manner in which they're elected.
Well, isn't it true that under your present system, your magistrates have certain administrative duties, whether it be by statute or whether it's duties that they have assumed, such as overseeing road construction and roads in their district and so forth?
Magistrates are specifically forbidden by statute
I understand that, but
to oversee road work, Mr. Barrickman.
I understand that.
Traditionally, that has been the case.
It is still the case, isn't it?
No, sir.
You mean they aren't the ones that come in with the recommendations
Oh,
to the
oh,
roads
no,
and so
no.
forth?
The fiscal court has the full authority to pass a county road and bridge program for improvement of the county road.
That's my point.
That's exactly correct. That's the fiscal court.
And yes, but it is true that the sitting magistrate in his district is the one that usually comes in with the recommendations and is the one that checks that for the needs in his district.
Well, the responsibility for the recommendations statutorily lies with the county road supervisor, who has very specific authority granted to him by statute. Among that is deciding which, by making determinations on what land is favorable for the establishment of a quarry, for example, what rock should be used in a certain area and what shouldn't be used, and this sort of thing. So those improvements are generally the responsibility of the county road supervisor to recommend. However, your point is well taken in that the magistrate or commissioner, as far as that, because we don't need to lose sight that the commissioners are nominated from a district. They serve a district just like a magistrate does. Their road and bridge program would be passed and approved just like the magisterial form would be passed and approved. So a commissioner, sure, a commissioner would have a particular project that he believed was in the best interest of his district. He'd bring it to the full court, and the full court would consider the project. Magistrates do the same thing. They have a particular project in their district that they believe needs to be an improvement of a county road. They bring that to the fiscal court, and the full court considers it and either passes it or either approves or disapproves.
But the commissioner is going to have an added responsibility because he's got a larger district.
If we had 3 magistrates instead of 7, which the Constitution, which the statutes allow, then there's not any difference. It just
But the point is, Judge, and I'm not arguing with you, the point is, you've got 7 now, and if you reduce it to 3, you're obviously going to increase the number of people that the 3 are representing, and he's going to have more responsibility than the magistrate.
He'll have to work a little harder to do the job. I agree.
That's my point.
Exactly like we do in Warren County. As I mentioned earlier, Warren County has a population of about 85,000. They have 6 magistrates. That's 1 for 14,000. Barren County has a population about 36 to 38,000. If we have 3 commissioners, they represent a little under 13,000. Very similar ratio that exists in Warren County.
If the voters decide to go to the commission form, do you think that the budget in the county is going to be less or more because of the change? And either way, what's going to cause it?
If let's do this hypothetical. Let's say that I am a candidate for re-election in 1998, and I am re-elected and serve as county judge executive. Let's also assume that the commission form of government passes this fall, and then I have a fiscal court with whom I work, composed of 3 commissioners and myself. I propose to them a budget that includes salary arrangements and the similar sort of thing. I cannot imagine that I would propose a budget that would be substantially different than the one we presently have, even including the individual salary and benefits package for the commissioners, were they to be commissioners as opposed to magistrates. So if the question you're asking me, are you going to propose a budget to pay the commissioners more than you do the magistrates? No, sir, I don't believe I would. I believe that the capacity is there for those people to serve 13,000 as well as it is for them to serve 5.
Well, is it your opinion that the budget is not going to be materially affected by change?
I don't believe that it would.
Either up or down?
No, sir, I don't believe it'd be materially
That's
affected.
the point I'm trying
Okay,
to
if that's your
get.
point, no, I don't think it. I think you're going to have the same concerns about roads and bridges, the same concerns about general services, the same concerns about our ambulance service, our 911. I don't think any of the demand on the part of the citizens for county services will be materially affected, and the dollars are going to be substantially the same, given House Bill 44, which allows us to increase revenues only by 4% annually. So I don't think the budget's going to be materially affected whether we have a magistrate form of government or a commissioner form.
You got any comment?
No, sir.
I've got another question. We've got about 4 minutes. Let's assume that John Doe lives out in Knob Lick. We have the commissioner form of government. Is he going to be able to have as much influence and as much contact with his commissioner, who's representing a whole lot more people, as he would with his magistrate?
If John Doe wants to participate in county government, which we've encouraged him to do, well, first, if he's in Knob Lick, he's in Metcalfe County and not Barren.
I'm sorry, I did
Let's
say
say
Knob.
Hiceville. Let's say
Okay,
Hiceville.
Hiceville.
Then, yeah, John Doe in Hiceville would have the same access to his commissioner as John Doe in Hiceville has to his magistrate.
But he's going to have more problem getting to him.
I don't know
He's
that
not going to be living in his community and so forth.
I don't know that that's a valid point, Mr. Barrickman. One recognizes that the commissioners, or if we reapportion the county and go down to 3 magistrates or 4 or 5, or if we go up to 8, the initiation of contact between a commissioner and a constituent, or a magistrate and a constituent, generally begins with a constituent. If the constituent is desirous of speaking to the county judge executive, I can testify to you that they find a way to get to me, and that I make myself available to them, just as a commissioner would, just as a magistrate would, just as any elected public servant would do. I don't think it's going to reduce access at all. I believe that there will still be contact between the commissioner and the constituent as there is between the magistrate and the constituent. There's one other thing about this, the community question that came up just a few minutes ago. This isn't going to affect the identity of our communities. It should, in fact, enhance them, because the county judge executive, and I can tell you that I, as a county-wide elected member of fiscal court, attend and appreciate the events that take place in our communities around Barren County. The making of a community has nothing to do with arbitrary boundary lines. The making of a community has to do with the people that live in it. Those are the people that make the roller coaster fair a fun thing to do out in the Temple Hill community. Those are the people that went to Hiceville a couple of 3 weeks ago and honored the folks that finished school in the Hiceville school. Same thing is going to take place this coming Sunday in Park City at the Lions Club. Communities aren't made communities by arbitrary boundaries drawn on a map. Communities are made communities by the people that live in them.
Gentlemen, I want to thank each one of you for being here. I want to emphasize that as far as I'm personally concerned, I am neither advocating the passage or advocating the defeat of the proposal. And for your information, and I know you know it anyhow, but as far as the public is concerned, I want them to know that Mr. Richardson and I didn't discuss this program one iota before we arrived here tonight.
As a matter of fact, he didn't even tell me what time to come.
He told me what time, so I'm going to, no, Mr. Barrickman, I know that. I know you well enough to know that everything that takes place here is on the up and up, and I appreciate your comments.
Well, I appreciate your coming, and I think that we covered the question rather well, and I urge every citizen to go out and vote on this question. Don't neglect it, because it is important to the county. Thank you very much.
Thank you very much.
Live from the Glasgow Electric Plant Board, Glasgow Wants to Know. With your host, Mr. Uhel Barrickman.